Foedus, which means a treaty, pact, or covenant. Our Constitution is a pact among very different states to share their power. Our founders saw the dangers of a strong central government. Old King George, an ocean away in England, could not effectively govern the rugged American colonies. On the flip side of that, under the Articles of Confederation, our government couldn't even raise an army to put down a rebellion. So the founders drew up a new pact or covenant among the states, and the states signed on to it. They drew a line between matters that required the collective action of the federal government, like national defense and, I guess, interstate commerce, and more intimate matters that were better handled at the state level. We see this today in some of the most hotly debated political topics of our age. Drug policy, immigration enforcement, and even daylight savings time all vary across state lines, just like slavery and prohibition did in times past. Where that line ought to be is a debate as old as our very nation, and we have a wonderful panel of judges here today to engage in that line drawing. But first, it is my honor to introduce our moderator, Professor Jonathan Green. Professor Green researches political and legal history extensively and has been published in several journals of intellectual history, as well as our very own Arizona State Law Journal. Professor Green, I really hope I got most of my history right in my earlier remarks. I'll take your class if I didn't. He holds a JD from Yale and a master's and PhD from Cambridge, and there is no one more qualified to guide this discussion. Everyone, please join me in welcoming Professor Jonathan Green.
All right. Well, welcome everybody. Welcome to Phoenix and to ASU. We're so thrilled to have you guys joining us today. So I guess I'll just start by introducing our panel before we kick things off. So just to my left here is Justice Clint Bolick. Justice Bolick serves on the Supreme Court of this state and has done so since 2016, is that right? And was retained in elections in 2018 and 2024. And before his time on the Arizona Supreme Court, Justice Bolick was a litigator, worked for the Goldwater Institute, as well as the Institute for Justice, litigating questions around private property, school choice, a number of other important areas. He's also a regular guest here at ASU, and I should just say on a personal note, since I arrived here at ASU a couple years ago, Justice Bolick has just been extremely welcoming and kind to me personally. So really grateful to have you on the panel with us. Just to Justice Bolick's left is Judge Johnstone from Montana. Judge Johnstone has been on the Ninth Circuit since 2023 and is a law professor as well. He teaches at the Alexander Blewett School of Law in Missoula, Montana, which is the University of Montana's law school, and is also has a good deal of litigation experience at Cravath, as well as his own Johnstone PLLC. He's worked in the Montana Department of Justice as the state solicitor and as Assistant Attorney General for the state of Montana before that. And following law school, clerked for Judge Sidney Thomas of the Ninth Circuit in Montana as well. Just to Judge Johnstone's left is Judge Justin Walker of the DC Circuit. He has been on the DC Circuit since 2020, and before that was a district court judge on the Western District of Kentucky. He also has litigation experience at Gibson Dunn and at Dismore and Shoal. Am I saying that correctly, Judge Walker? And also has taught at the University of Louisville's law school, so you might be sensing a theme here from our guests on the panel. He's a former clerk to then Judge Brett Kavanaugh and Justice Anthony Kennedy. And finally, at the very end of the table here is Justice Evan Young of the Supreme Court of Texas. He was appointed to the Texas Supreme Court in 2021 by Governor Greg Abbott and was retained by the voters in 2022. He's a former clerk to Justice Antonin Scalia and worked in the U.S. Department of Justice among a bunch of other places, and is also, because he has good sense, a adjunct professor at the University of Texas's School of Law. So we've got a bunch of law professors in addition to a bunch of judges on the panel for you here today. Surprise. Okay, so I guess just to kick off our discussion of federalism and subsidiarity, let me kick it over to our panelists. Maybe we could just start by kind of defining the terms of debate. So what do we mean when we talk about federalism and subsidiarity? How are those concepts related to one another? How might they be different? And the comments we heard just a second ago teed up some of the values that federalism and subsidiarity might be thought to further. But could you maybe just say a little bit more about what those values are, and then maybe some of the risks associated with the devolution of political power to the states and localities? I'll open it up to anyone who has thoughts, or I can take the moderator's prerogative and tell Clint he has to start.
Well, I guess I will, and as one of the two homeboys here, I am very excited to join Professor Green in welcoming everyone, including my co-panelists who are from out of state. This is a pretty spectacular place, isn't it? And my court gets to hold arguments here once a year, literally right here, and sometimes with the doors open, which is actually both really cool and very unnerving. But and then also having the opportunity to teach survey of individual rights here every fall is really a blast. This is such a distinguished panel that I actually offered to tend bar rather than speak, but the Federalist Society has not yet done morning bars, which I think would be a wonderful innovation and perhaps make some money as well. Yeah, I hope Sheldon is listening to that. But in any event, I will just start with my brief definitions of federalism and subsidiarity. Federalism, I think, is generally understood as the residuum of appropriate, or I should say legitimate government authority that is retained by the states after they surrendered some of their authority to the national government. So the national government is a government of defined powers, with the remainder of those powers residing in the states, including, and very, very importantly, the police power, the power to regulate health, safety, and welfare. This is, of course, memorialized in the 10th Amendment. The 10th Amendment fell by the wayside during the New Deal. In fact, in one case, it was referred to as a truism. Today, I think it is far more vibrant. In fact, I will surely say later on that I think that we are living in the golden age of federalism. But federalism is confined by the adoption of the 14th Amendment. And I am both a Federalist and a 14th Amendmentist, if there is. There's got to be a more elegant way to say that. And we have to recognize that, that the national government does set a floor for the expression of the protection of our fundamental civil rights, but not a ceiling. As I know Justice Young believes also very, very strongly, state constitutionalism is a very important component of federalism, though often overlooked. Subsidiarity, and Justice Young and I were chatting about this a few minutes ago, is not a term that is often used in the United States. It is very often used in Europe. And it basically means home rule, local rule, and that sort of thing. This may be a controversial view, but I do not think, unlike federalism, which I think is a core of our constitutional system, subsidiarity, the idea that decisions are best left as close to home as possible is not, in my view, a constitutional value. The states are the organic players in our constitutional system, and then the states determine the role, the powers that local government would have. And I would just finish by commending Federalist number 10, in which James Madison talks about one of the major values of having a national government, because special interest groups called factions at that time, am I talking about 10 or 5? I think I'm talking, yeah, 10, thank you. Factions have their greatest play at the local level, and I think we see that manifest all the time. But that's the notion of subsidiarity. It's something that I think as a policy matter, you can either favor or oppose, or favor in some instances and oppose in others, but it is not a constitutional feature of our system.
Let me be the first of my colleagues to welcome you also to the Ninth Circuit. The Phoenix, actually the Phoenix courthouse is in many ways now the center of gravity of our current court. I think we have more, looking at my colleague, Judge Bumate, I think we have the plurality. We have the most circuit judges sitting in our courthouse in Phoenix, including our current chief judge and our past chief judge.
I didn't.
And actually, my third sitting was right here, and so it's a delight to be here. It's also a delight to be back with the Federalist Society. In my 3L year at Chicago, we hosted the Student Symposium. I have such great memories of that, and I'm pleased to be able to continue my engagement. I think Justice Bolick has laid it out pretty well. I guess I'd say that subsidiary is one value in federalism. Liberty is another value of federalism, but federalism has lots of things going for it. But it is its own thing. We shouldn't confuse, I think, neither federalism with subsidiarity or federalism with liberty. They can be at cross purposes. They're just different things. I think I used to teach state constitutional law. I really, except when I'm in the presence of my colleagues on state courts, I still kind of think of myself as a state guy by disposition, and where most of my legal career was spent. But I think we can think of, to pull together the two sides of looking to local and federal power, to think of states as the kind of the key fulcrum on which this balance of power rests. In both ways, again, there are kind of key differences, but if you look at both the federal constitution and our state constitutions, actually state constitutions are quite a bit more explicit about subsidiarity and other values, who has what power versus the central and local authorities than the federal constitution. It's largely a structural principle we're drawing from the federal constitution. But in both cases, as you look out from the states to the federal government, as well as within states to the local governments, the principle of subsidiarity is one of the localities and the federal government have those powers that are expressly granted to them. But importantly, and of course this is where most of the action has been for most of the past century, certainly at the federal level, and has kind of always been there also for most of the past 150 years or so at the state level, is they also have implied powers under various structures. And so with respect to Dillon's rule, which is the more constrained view of local power within states, it's always included an implied power. Of course, at the federal level, we have the necessary and proper clause, which does a lot of work, a lot of, I think, sadly unacknowledged work as a former con law professor in federal constitutional doctrine. And what that does is allows implied powers. Now, at the local level, there is the possibility of an even stronger view of imperium and imperio, the idea that localities are really states within states that have their own kind of sovereignty. And there was a moment in American constitutional law in which localities were understood to have that, but that then settled into what we now call an idea of home rule. And home rule, which is a rule that the vast majority of states leave at least as an option to their localities, basically allows a locality to act unless the state says it can't. So it has, states can move forward and do things, but as we heard last night in the really interesting discussions of Waymos and other areas, that the state is always empowered, because municipalities are still creatures of the state, is always empowered to come in and override that. So again, I'd say that if we think about these values of subsidiarity, they're kind of mirror images of each other in various ways, looking out from the state in either direction. But it really is, in terms of American federalism, and particularly at the federal level under the US Constitution, just one of many justifications, another which is liberty, but that is also not the sole justification of it. The last thing I'd say is that as this group knows, that while James Madison was one of the Federalists, it's actually, I think, pretty hard to say that he was really a Federalist if we take that in terms of someone who believed strongly in the principles of federalism as we understand them today. On the eve of the convention, he wrote President Washington to say, really, just federalism, state sovereignty, state independence is just incompatible with the nature of the Union. But we're just going to, I guess, have to deal with it if we want this thing to work out. He famously proposed the federal negative on all state laws. He said it would be actually a happy thing for the federal government to control state laws bit by bit over time. And yet, and this will be kind of a theme of my remarks here, like all Americans, he mobilized the idea of federalism as soon as he disagreed with what the national government is doing. So famously, under the Adams administration, under the Alien and Sedition Act, with respect, by the way, to federal power over what we call immigration laws, he said, no, right? The federal government has no power over here. Stay out. It was also about the Sedition Act and the freedom of speech, but it was fundamentally and primarily an argument about the federal government not having those powers. And so federalism, I think, comes to us in the spirit of James Madison as exactly that, a principle that all of us, all Americans, will mobilize to keep this conversation and contestation over central and local authority going even to today.
Well, it is a great honor to be on the panel, and great to be in Arizona. As Clint and Anthony were speaking, I thought maybe in the spirit of the Ninth Circuit, I would try to find a couple places to dissent. Get to be Judge Bumate for a few minutes. I guess maybe I'll start with Clint's argument that we're in the golden age of federalism. I think in a lot of ways I agree. I think the important things that state legislatures and governors are doing today relative to what Congress is doing or not doing today looks different than a generation ago, and maybe looks different than ever before. And so in that sense, I think I agree. I also think I agree in the sense that the court has given us in the Rehnquist era and the Roberts era some good federalism decisions, including on commandeering and coercion. I am not totally on board with this being golden age of federalism for a couple of reasons, though. I guess one is that I think that the Rehnquist court and the Roberts court did not do a lot on reining in Congress's interstate commerce clause powers. So we're, of course, a federal government of enumerated and limited powers. I think there were some people, I won't speak for myself, but some people after the NFIB decision who had made a theme of the litigation, if Congress can do this, Congress can do anything. And then I think they came away from that with the conclusion that I guess the Supreme Court does think Congress can do almost anything. And then I guess I'm not sure that the current court with the Gorsuch, Kavanaugh, Barrett appointments seems as eager to even try in the way that at least the Rehnquist court made an effort and did Lopez and did Morrison, which I think were kind of were arguably small ball, but at least something. And so then I guess that raises the question, well, why? Why do they seem less eager to kind of go big in this area compared to some areas where they very much have gone big? And I think for one thing, there are stare decisis obstacles. For another thing, there are line drawing problems. For another thing, Congress is not doing a lot, and so there's not a lot of litigation to review for whether it exceeds Congress's enumerated powers. And then I guess the last area is almost a consequence of the conservative social movement's success. I think one of its great legacies is textualism and how prevalent textualism has been, and very much think that's a good thing. But it can lead judges to have blinders, or academics to have blinders in an area like federalism, where there is a 10th Amendment, but the 10th Amendment doesn't say which powers are reserved to the states. And so if you have to look to a textual clause, and here I'm borrowing from Professor Mike Greva's, I think, wonderful book, which I recommend, The Upside Down Constitution. You know, okay, you can look to the Dormant Commerce Clause argument, you can look to full faith and credit, you can look to import-export clauses, but there's not like this great federalism clause that you can say, okay, this is the text that I'm going to ground this federalism decision in. And I think we saw that in what I guess would be my last comment, was a missed opportunity, arguably a missed opportunity for the court, and that was in the recent pork producers case. I think some people who care a lot about not just vertical federalism, Congress versus the states, but horizontal federalism, how much can one state get into the business of another state, were very disappointed by that decision. And for those who aren't super familiar with it, California passed a law saying that you couldn't sell pork in California that had been produced in other states, or in California, but they don't produce a lot of pork in California, had been produced in a way that California didn't like. And so the effect of that was that California, which has something in the ballpark of 10 or 15% of the purchasing power on pork, got to dictate the production terms in places like Iowa and North Carolina about how the pork was produced. I can maybe say a little bit more on that later if there's an opportunity, but I'll stop there.
Well, good morning. I will concur with all of my colleagues in congratulating ASU on such a beautiful campus and for hosting such a lovely event. And I'll tell you something about myself that I don't say very often publicly as a statewide elected official in Texas. But when I do, what I say is often in response to a statement, an assertion that I'm a native-born Texan. I say, well, yes, I was born in far, far, far west Texas that some people call Arizona. And in fact, just a couple of miles from here at the Luke Air Force Base Hospital, where my father, an Air Force officer, was stationed at the time. And so I got to Texas as a gift of the Air Force, but I'm very pleased to have been brought into this world also as a gift from the Air Force right here in beautiful Arizona. So I'm glad to be here. I appreciate Professor Green changing it up when he got to me. Each of my colleagues, he kept on saying, and Judge Walker's to the left of Judge Johnstone was like, if he better not say that about me, I'm not the left of any of these people. But he said, and at the end is Justice Young. The question about federalism and, as Justice Bolick said, subsidiarity, a term that I don't really use that very often. I appreciate that it gives us a concept, a word maybe to reflect the idea that we want decisions to be made at a lower level of government, which doesn't necessarily, by the way, just mean home rule. It sometimes means the lowest level of government that there is, which is the individual. And those concepts are really important for us to think about as a society that's distributing power. Federalism, by contrast, isn't just about values. It isn't just about philosophy. It's the law. Federalism is a structural and textual principle in the United States Constitution that was formed by people who are acting through their states that preexisted the Constitution and that continue to exist in their individual and sovereign capacities. This year, 2026, is a very special year. We've got it, reflected in the special edition of the Constitution that begins with the Declaration of Independence, which usually is put into these things not because it happens to be the 250th anniversary declaration, but if you don't include the Declaration of Independence in the little copy of the Constitution, it won't hold together. There's just not enough paper. The Constitution is so short. It's a metaphor. It's a metaphor, almost, yes. In 1876, however, there's another special year. That was the year that the people of Texas adopted our Constitution. And so this is the fancy word for that is the sesquicentennial of the Constitution, or as we say, the texquicentennial of our Constitution. And I have a copy of the Texas Constitution, and if we have the U.S. one, it kind of drops down. It's like a little feather. If I were to drop the Texas Constitution, it would really awaken those of you who were out partying last night and managed to drag yourselves here nonetheless, because this, if you just have the Constitution, it's about 7,600 words. That's what the United States Constitution, all of its amendments is. In 1876, the people of Texas adopted a constitution. I think, well, how many words could it be? It's just a state, must be much fewer. No, it was 22,000 words, which is about the length of a Shakespearean play. We have amended our Constitution every other year. Every odd-numbered year we have an election. We added 17 new amendments in November of 2025. Our Constitution now is 110,000 words. That's half the length of Moby Dick. And this is one race that I'm actually glad that Texas is not number one. Are there any Alabamians in the audience? Your Constitution, if you're here, is twice the length of Moby Dick. It's 470,000 words, I think, the longest in the world. Why is it so long? Well, it's because, as some of my colleagues have mentioned, the people of Texas wanted to make very clear how power would be distributed in our state. And among those distributions of power in Article 11, which is entitled Municipal Corporations, we described what cities and counties could do. But notice they're called corporations. That's what most local governments still are. Most cities are corporations. They were formed by the state. They did not form the state. When, in 1876, the people of Texas gave us our current Constitution, many times amended, it wasn't Brenham sent its delegation, and San Antonio sent its delegation. It was the people of Texas who sent representatives to Austin to be our framers, and then the people of Texas adopted the Constitution. And what did we really say about local governments? We said that the legislature could charter them. And we still talk about city charters and things like that, right? The Constitution of Texas in Article 11, Section 5 has what we now call the Home Rule Amendment. That was not part of the Constitution of 1876. That was adopted in 1912. When that was happening across the country, states were thinking, well, let's let cities do some more things for themselves. But it wasn't because of subsidiarity in the sense that we have a constitutional obligation to allow that to happen. It was more a matter of efficiency, because the legislature of Texas was spending a huge amount of its time, its precious legislative time. We let our legislature only sit for 5 months every other year, which is a wonderful thing in so many regards. But what if a huge amount of that time was chartering cities and amending charters to cities? They said, well, we don't have time for this. If you're 5,000 or more, you can follow these procedures and you can choose to become a chartered city if you want to, if people want to. And here are the ways that you can amend your charter. But then the home rule, there's nothing in the text that actually talks about home rule in terms. Those words are not in the Constitution. What the Constitution actually says is no charter or ordinance enacted under such charter may contain any provision that is inconsistent with the Constitution of the state or the general laws enacted by the legislature of the state. And that's the supremacy clause. It's actually more powerful than the supremacy clause. And so the way I think about these issues is I return to one of my favorite characters in literature, who of course is Baby Bear. And I think about the national government being too big and the local governments maybe being too small. And so in addition to Baby Bear's porridge and chair and bed, we have Baby Bear's polity, and it turns out to be the state. The state is just right. And then it becomes a question of values and policy about how the state chooses to delegate authority to the various sorts of instrumentalities that the state will create. Cities, counties, drainage districts. We have all sorts of entities in which units of government smaller than the state exercise what actually is the state's power. And it's a good thing to have it to many degrees. Here are some of the positives. The more we have local governments, the more that individual citizens are able to participate in the self-government of their society, to build up the muscles of what it means to be a citizen, which then is useful in their roles as citizens of their state and of their country. The more practice we give people in managing their own affairs for themselves, for their families, for their homeowners association, for their cities and counties, community college districts, hospital districts, all the rest of it, the more likely they are to pay attention to those higher order questions that affect us all in Texas or Arizona or other states and as Americans. That's a good thing, I think, obviously. It advances the cause of peace. The more that we give people in their localities the opportunity to make decisions that will affect their daily lives, the less likely we are to have battles in Austin, physical or metaphorical, because now we're letting people in different parts of our state make decisions and they can live peacefully. And if you don't like the way that they're doing it in Reeves County, well, you can move across the county line if you want to. So there are lots of advantages, including potentially more freedom. The more that we let people govern themselves, perhaps the more that we will experiment with the idea of allowing the people at the lowest level of government, the individual and the family, to have freedom to make decisions on their own. But there are countervailing concerns as well, including less freedom, because the more you give smaller units of government the ability to make decisions, the more opportunities you have to restrict people's freedom too. And sometimes it's hard to tell exactly which one it is. And so, as an example, in the city of Austin, which is somewhat different in its outlook on life than much of the rest of Texas, the city council, members of whom might honestly, in some instances, be at least as comfortable serving under Chairman Mao as under the mayor of Austin. The idea was we will allow for public camping in all parks, green belts, whatever else. If it's someone who says, well, I don't have a home, pitch your tent wherever you want to. And maybe in a sense that sounds, well, that's liberty. That person now can pitch their tent. You know what I would also like is to have a view of the lake, from my home. Well, all these people got to have that. What happened then? Well, all of the trails and the areas in which the rest of the public used to be able to run and exercise and let children play and young women before going to work, even in the dark, run along the trails, that basically stopped. Is that also a restriction on liberty, perhaps? Sometimes it's not so clear whether something that sounds in a vacuum like that might be an enhancement of liberty might actually be a degradation of liberty. And then even more things, the restrictions that can be imposed in Austin on cutting down a tree, If you have on your property a tree that's basically more than a sapling, you must go through an inordinate amount of bureaucracy in order to have it approved that you can cut down the tree, including cedar trees, which are some of the most evil parts of creation. Anyone who's from Austin knows this. Eventually, you're going to get cedar fever, and these are trees that drain the water, which is such a precious thing in Austin, and somebody chopped down some of their cedar trees, and they almost went to jail for it. Like, they should be getting a medal for this sort of thing. So there are values, in other words, and the legislature responds sometimes, says, no, we're not going to allow that kind of open defiance of public spaces. No, we're not going to allow cities to ban plastic bags. Now, does the state need to do that? Well, there are questions, values about certain things that as a state, the state may want for good reasons or maybe for bad reasons to say we will have a uniform practice. And the point that I'm really trying to make, and I'm going to stop making it here in a second because there are so many other things we want to get to your questions, is subsidiarity, if that's the term we're going to use for local control. I think that is something that's more philosophical. It's not really for judges, honestly, to be opining about too much. You know, we can't stop ourselves. Here we are, we're going to opine. But it's for the people of the state to be thinking about and to constantly be adjusting. Where on the balance is it in which we want to be able to allow the peace that will result from allowing different parts of our state to make different decisions versus threats to important uniformity values so that people will know what's expected of them, whether they go across the city line into one other township or whatever else. Where do those lie? And that's something that the people of the state constantly should be adjusting and thinking about. They can take control back as the state. They can devolve authority to local governments that that the state itself creates. And that's a positive thing. That's part of a strong self-government, is to even think about what self-government itself actually means. And so, with that, I'll rest for a moment.
Well, great. Thank you to all of you for those initial thoughts. I guess maybe let me put one or two more questions to the panel, and then we can open it up for questions from the students as well. I guess, Judge Walker put the question of horizontal federalism on the table, and I'd be quite curious to hear from our two state court judges how things look from the state level after the pork producers' decision and some of the court's other decisions that touch on the question of one state's power to, in effect, impose regulations on out-of-state citizens or corporations. And then I guess this is also an invitation for Judge Johnstone, but Justice Bolick and Justice Young and Judge Walker as well, just to say a bit more about ways in which we might see the court's jurisprudence around not only the Commerce Clause, but also its individual liberty decisions, which very often have the effect of removing or limiting the police power of states in various ways. So one very concrete example of this is the court's decision in Timms versus Indiana from a few years ago, which incorporated the excessive fines clause against the states, which had not formally been incorporated against the states. You might think that's a good idea, bad idea. It's constitutionally required, not required. But one of the things that it definitely does is it means that the state of Indiana and every other state is now held to the same standard for the same rule against the imposition of excessive fines against its own citizens that the federal government has held itself to for a while. Which is, in practical terms, a diminution of the regulatory authority of the states. So this sort of thing has happened in a number of other areas as well. And so I guess I'd just be curious to hear the rest of the panel's thoughts on some of Judge Walker's suggestions that we might not see the court be making such aggressive steps in the context of federalism and the Commerce Clause and some of these individual liberty contexts that we've seen it take with respect to the administrative state, presidential powers, and those sorts of things. So,
Start with someone else.
sure, yeah, Judge Judge Johnstone, or go back to Justice Young as
Are
well?
you cold calling me? Well, as was very apparent to the framers, the federal judicial power vested in the Supreme Court and such inferior courts as Congress may from time to time ordain and establish is also federal power. And I think that's something that we should remember. It can be federal power that can be used to, I mean, it must be used to faithfully draw the lines that the Constitution does draw. But in these gray areas, including dormant commerce doctrine, not a clause, and in other areas of federalism, to the extent we get further away, I agree entirely with Justice Young that federalism is law to the extent we locate it in the text and the structure of the Constitution. A lot of these debates, at least under current doctrine, and as Judge Walker said, the text is kind of way in the background, right? If we think about the commerce power, if we think about Section 5 of the 14th Amendment and the enforcement power, which was really supposed to be the centerpiece of our second founding. So that's the first thing I think to understand that I certainly think about, I thought about as a professor and as a litigator for states, and I think about it as a judge, is that I'm also exercising the federal power, and by doing so am displacing, perhaps because it's my job, but am still displacing the decision-making of other actors, not just vertically in terms of judicial review, but also horizontally in terms of the room for states and localities and people to make their own decisions. I guess to pick up on a different aspect of Judge Walker's point in terms of some disappointment, some people's disappointment about kind of where the court has gone with federalism, is to make a slightly different observation, but even on the terms of liberty, which is really the framing principle of this panel, it's actually kind of hard to see that liberty, for as much as it was, to take Judge Walker's former justice, to take Justice O'Connor, as much as they talked about federalism as being a guarantor of liberty, it's hard to see necessarily the ways in which a lot of the more recent federalism decisions are actually doing that work. And this isn't a new critique, but right, if you can go all the way back to the civil rights cases under the 14th Amendment and the way that the court had constrained and still constrains enforcement of the Fifth Amendment, of the Section 5 of the 14th Amendment. The through line all the way to City of Bernie is the best example. Right, if you believe in free exercise of religion and have a view of that is not the Supreme Court's conventional view in the past, if Congress had a view, that view may, separate discussion, that view may or may not be more faithful to the Constitution itself. But if you believe in that, City of Bernie was opposed to that form of liberty. Think about remedies. Morrison, thinking about the personal safety and particularly the safety of women, Morrison removed a remedy for a violation of personal liberty and autonomy. It gets a little more complicated with cases like Prince from just over the county border in Ravalli County from where I live, and the healthcare cases. But I think if we assume that we're all kind of repeat players in this game, including Congress, Prince, I mean, of course, one argument there, and this was explored in the dissent, is that by having an anti-commandeering rule set aside its merits as a faithful interpretation of the Constitution, I think it is important to have some terms of dealing between states and the federal government. But one of the effects of that is to remove local officials, local law enforcement officials who may better understand the balance of liberty and safety in their own communities from the equation, right? So if Prince tells us that the federal government cannot use local officials to do its work, NFIB, right, similarly, if that tells us that it cannot use state officials to do their work, the response, if Congress wants to do something, and a lot of the time, the constitutional law is about not whether you can do something, but how you can do something. If Congress wants to do something under both Prince and the healthcare cases, its option now, if it wants to get it done, is to do it itself through the federal government. And it's not at all clear that that's furthering liberty, and I think there are good arguments that it takes away liberty. So the last piece of course, is some of the earliest arguments for federalism principles that have resided in constitutional doctrine at the federal level is sovereign immunity, and talk about remedies. I mean, so if we think about the deterrent effect of remedies on state exercise of power that can take away people's liberty, sovereign immunity is a form of federalism. And again, so I think if not most, certainly much of our current federalism doctrine is not just kind of, well, it may be in dicta, there might be lines in there about liberty. It doesn't seem that its primary motivation is the preservation of liberty. Otherwise, I think our federalism doctrine might look quite different. And I think, again, maybe that's perhaps my friend Judge Walker's point.
I want to build on what Anthony said and really what Clint and Evans said as well by talking about when it comes to federalism and subsidiarity, a risk and an opportunity. So the risk is all over the Federalist 10 that Madison wrote and that was mentioned earlier, and goes very much to Anthony's point about, you know, federalism done appropriately is a means to protect liberty, but not every decision that gets labeled like pro-federalism is a vindication of liberty. And what Madison said, I'm going to use some different words, but he talked about the dynamic that I'll call the two wolves and a lamb. And if they vote on what's for dinner, that's bad news for the lamb. But that's democracy. And so the great struggle, and he saw this, by the way, in the States at the time. He was very, very skeptical. I mean, that's why he writes to Washington. It wasn't like a theoretical, abstract problem for him about, oh, man, the states might kind of be threats to freedom and liberty and democracy. He was seeing states taking away the political minorities' liberty. And he says in Federalist 10, one of the solutions is going to be that it will be more difficult for a faction, the two wolves, to take away the rights of the political minority, the one lamb, if you're on a national scale versus a local scale. And he says one of the reasons it's going to be more difficult is there's just going to be a lot more interests. So it's going to be more difficult to get to 51%. And then he says another thing is going to be, even if there is like a faction out there that can get there, it's going to be harder for them to cooperate if they have to do it on a national level. This goes very much, I think, also to Evan's comment about Austin, and you know, the majority decides to do something that really makes life quite worse for the minority sometimes. Now, part of the great beauty of federalism, and I don't want you to take what I just said, and I don't want you to take what I said earlier about textualism and say, okay, well, Justin Walker doesn't like textualism or federalism. Okay, like, very much in favor of both. Okay,
I told you I was not to his left.
But one of the beauties of federalism, and Evan mentioned this briefly, is the freedom to move. And it's wonderful not just because sometimes you do move, and you saw this especially during the COVID era, where people just didn't like what their state governments were doing or their home rule local governments were doing, and so they went to Texas, they went to Florida. But in addition to actually moving, there's great value in the threat of moving, because the state legislature or the local city council has to reckon with the possibility that if they do too many bad things to a political minority, the political minority will move and they'll lose the benefits that that political minority brings to the community. And the costs of losing those benefits might be to the political majority greater than whatever the benefits would be by just imposing their will. Now, that breaks down, that wonderful aspect of federalism breaks down. Now I'll come back to it in the poor producer's case. And I'm not, I guess, I try to be cautious as a lower court judge about saying a Supreme Court decision is right or wrong. So I'm not going to say whether it's right or wrong. I'm just tell you the argument against it in the context of the freedom to move is if California can dictate the terms for Iowa and North Carolina, then the people who don't like the rules in Iowa and North Carolina, they can't move. There's nowhere else to go. And you know, Justice Kavanaugh mentions this in his dissent in the poor producers case. He says, imagine if a state says, well, we're not going to sell products that were manufactured by companies that provide abortion services, pay for the insurance for abortion for their employees. And then imagine another state says, we're not, so maybe Texas passes that law. Then imagine California passes a law saying, we're not going to sell products that were made by companies that fail to provide health insurance that covers abortion services. So now a company is going to either lose the market in Texas or the market in California, and those are, number one, huge markets, and number two, going back to Madison and the convention, that was the point. That was one of the main points of a union, was to have a nationwide market. I guess the last thought on this is, you know, the pork and the hypothetical go somewhat to cultural issues, but this is probably seen at its most extreme, and again I'm borrowing from Professor Greva here, when it comes to taxing and spending. So if a state wants to tax a political minority to benefit a political majority, they have to reckon with the possibility the minority will move. But if they can get Congress to tax everybody and then send the money back, sorry, not tax everybody, tax the political minority in every state, and then get Congress to send the money back to the states, that now they have trapped the people in their state, right? Because there's nowhere else. You want to move to another state that has lower, no, they still have to pay those taxes. The Supreme Court has reckoned with this hardly at all. And again, partly, probably because there's not like a textual clause in the Constitution that says, you know, the 10.5 amendment, the 10.5 amendment that says Congress can't do this. There's not a 10.5 amendment that says Congress can't do that. Last comment, so I don't land on such a downer, is I think that Anthony was talking about decisions that don't have a federalism name, but that can vindicate federalist interests, state interests. One of the areas the current Supreme Court seems very eager to make moves in is administrative law, which is one of the favorite topics of mine. And every time that a decision like Loper-Bright or a decision like West Virginia says that something can't be done in a certain way by the administrative state, even if it can be done by Congress, it often won't be because it's harder. That's why the administrative state did it in the first place. And that then gives the state more freedom to move because there's not a federal rule that is dictating the terms. Congress could make it, but it's too difficult to pass a law. The administrative state would do it because it would be easy, but they can't if it would be unconstitutional for them to do it. So I'll stop there.
I think you want to.
Sure. Sure. So I agree with a lot of what my colleagues have said. I think the default principle of federalism is that states are more reliable guarantors of freedom than the national government. But that default principle is utterly and totally not been true in many instances, obviously, most notably with the institution of human slavery. So in the national constitution, as a result, we have provisions that that seek to correct instances where the states don't play well with others. The Commerce Clause, I totally agree with Judge Walker. The point of that was to create a national market. I am very proud to have litigated the direct shipment of wine to consumers case under the Commerce Clause. So next time you buy a bottle of wine and have it delivered to your house, please toast me. But oh boy, that is the one case that I have personally benefited from a great deal. But certainly the Commerce Authority was designed to create the open market and to prevent protectionist trade barriers among the states. That is why the pork decision, aptly referred to, is such an abomination. And as state judges, we are far more free to call out the U.S. Supreme Court than federal judges, and I certainly revel in doing that. And another example, of course, is the Privileges or Immunities Clause in the 14th Amendment, which I believe was designed to incorporate the entirety of the Bill of Rights against the states, but obviously that is not a majority view on the U.S. Supreme Court at the moment, at least that I know of. To return to my theme of the golden era of federalism, I agree with my colleagues that from the perspective of Supreme Court jurisprudence, it's more like the Bronze Age or the Pewter Age. It's really not, we're really not there. What I'm referring to is the exercise of federalism, that people are voting with their feet by moving from states like California to Arizona and Texas. And, you know, obviously that is true in many instances. I saw some amazing demographic data recently talking about states that where there is growth among, with babies, liberal states have negative population growth. More conservative states have positive population growth. I mean, there's so many instances in which people making their own decisions as federalism was intended to do, and as Justice Kennedy, in what I consider to be by far his best decision in U.S. versus Bond, described as the virtues of federalism. But federalism today is playing a more important role than even I think was intended, primarily as a release valve. We are red versus blue America right at the moment, and it's more important than ever for people to be able to reside in places that reflect their values. And our ability to do so, our mobility, is an important part of that. We see more and more instances of what I refer to as civil disobedience federalism, where the states lead and the national government follows. Probably no better example of this was marijuana legalization. To my knowledge, it's still illegal at the federal government level, and yet it is ubiquitous in its legalization at the state level. I'm happy to say that a similar instance occurred right here in Arizona when I was at the Goldwater Institute. We hatched the idea of right to try. That is the ability to try for people who are dying to try experimental drugs. I told my boss when she said, we're going to do this, I said it is flatly unconstitutional. The United States, the federal courts will smack this down, and instead the reverse took place. The revolution that we started here in Arizona spread to many other states, and then to the national government, which actually adopted right to try. And the most amazing thing to me is that Democrats are now embracing federalism. It's okay if you audibly gasp when I say Gavin Newsom is now an advocate of federalism. And it's precisely because of what Judge Johnstone said, which is Republicans always embrace federalism until they're in power. And then they reverse it. And now Democrats are filing AGs as well as governors are filing dozens of suits against the national government. The only thing they have not been able to do is to use the F word, federalism. And they just can't say it. But they're doing it, they're practicing it, they're arguing it, and I think that the more people who do that, the stronger federalism becomes. And I just want to add one last comment because this is a huge issue for me. Justice Young, I want to create an exchange program among state Supreme Court justices because I need you on my court when it comes to charter cities. We have had since the 1940s this test that the Arizona Supreme Court created as to whether an issue is predominantly local in nature or predominantly statewide in nature. So anytime there is a clash between state law and municipal regulation, they go to court, the taxpayers get to pay the bill for both sides, and we apply that test and come up with a winner. But when you look at the actual words of the Constitution, and I have this quirk about me, I don't care what the parties argue, I always start with the words of the Constitution. And they say that charter cities have X powers, quote, subject to the laws of the state. I love your terminology. It's like a super supremacy clause. And so when state law and local law conflict, the state should always prevail. Does that make me happy as a policy matter? I don't know. Sometimes yes, sometimes no. But as a textualist, I think, and one of my colleagues referred to my concurring opinion making that point as gratuitous because none of the parties had asked us to overturn that prior precedent, and so I held forth about why my view was different.
Just a point of personal privilege with my friend. I don't think I said that either Republicans or Democrats had views on it. I said James Madison, so I said Democratic Republicans are fair weather Federalists.
I extrapolated from that.
So the golden age, or bronze, or silver, or clay of federalism, maybe it's some of all of that. Maybe it's the statue from chapter 2 of the book of Daniel with the head of gold and the feet of clay. And remember what happened to that statue. We have to be very careful. The way in which I think about it, though, is that there are multiple aspects of strengthening federalism. One, and Judge Walker mentioned, we're not really seeing restrictions on Congress's power that might infringe the authority of states to be able to govern themselves. But what the Supreme Court has done is take the judiciary out of a lot of the federalization of the law that previously meant that people like Justice Bolick and I didn't have a whole lot to do. We could play golf a lot more back in the old days because almost every question was so pervasively federalized that people didn't bother to even cite the Arizona Constitution, certainly the Texas Constitution. It's one of the reasons the panel last night talked about this. In Texas, we have 110,000 words. We have everything that the federal Constitution has, often in far more detail. Look at our Takings Clause. Look at our Religious Liberty Clause. They are far more dramatically expansive in what they say about the protections that Texas affords than the very concise, Spartan, beautiful, yet short and abbreviated federal protections. And historically, people would mention that the Texas Constitution has the takings clause, and they would cite only federal cases. And I think that in part was people just, the oxygen for state law had been so depleted. And the Supreme Court, by virtue of withdrawing from so many fields, has enhanced the role of states to govern themselves in those ways. Now, as to Congress's actions being struck down, sometimes federalism is enhanced by Congress acting. And so we talk about the pork producers case, we talk about the Commerce Clause and the desire for a national market, but look what here's my handy-dandy 250th anniversary copy of the Declaration of the Constitution, Article 1, Section 8, Clause 3, the Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. It could have said, but didn't say, there will be a national market that states may not infringe. And so, yes, I do think it's clear from the evidence that the goal here was to have a national market, but the mechanism to have a national market was to empower Congress, which at that point was much, much more representative of the interests of each state thinking about how it wanted to be protected. The Congress would have the ability to act. And so in the pork producers case, at least one way of reading what otherwise seems like a very disappointing decision is to be an invitation, probably a pointless one, because Congress, as Judge Walker says, doesn't really do much of use anymore. Maybe that will change, though, if people start thinking that the consequence of Congress not acting is not that the courts will continue to solve every problem. And one message I hope you all will take from law school, certainly from events like this, you should not be judicial supremacists, whatever else you are. The judges are not here to solve every problem. We're here to apply what the Constitution says and to hold a mirror up to the American people and say, here's what your law is, and if you don't like it, you should change it. That's what we do in the state of Texas. Here's what Texas law is. I don't love what I see in the mirror every morning. I didn't really love it this morning when I looked in the mirror, but I need it to be an accurate mirror so that if there are changes that I can make them. And so if what the Supreme Court is saying is, look, don't count on us to determine when the national market needs more regulation because the Constitution says Congress is charged with that duty. And if you don't like what's happening, turn to Congress. And here's what might happen. Remember I said that subsidiarity has as among its values peace. Well, so does having the ability of federalism to thrive in ways in which states cannot oppress each other. If we have situations in which California and other states are able to impose their will on the rest of the American people, there will undoubtedly be responses. And the state of Texas, the state of Florida, other bigger states are probably better positioned to try to fight fire with fire, which would be a disaster. I think that the long-term survival of our union depends on the idea that federalism allows us to be different. And if the people of California only want to eat pork in which the hog was massaged, by especially California licensed masseuses, all this kind of stuff, fine. But don't insist that the hogs in North Carolina require your hogs to be, whatever, right? And the point that I'm trying to make is that it is such a temptation when power comes to us to try to use it to impose the things that we think are right on everyone else. And sometimes it is right to do that. None of us, I think, in this room would say, well, if only we could go back and just have one more conversation in 1861 and persuade the North, just let the South do what they want. Let's just, we have a union here, you don't have to have it, but let them. No, there are some values that are just that important. But what are they? Can we be very cautious about trying to reach across state lines or at the national level to impose uniform values on every state? At the state level, should we be cautious about things that we insist there be no variation? We have the right to do it. The legislature creates the general laws that all the cities have to follow and all the people have to follow. But should they be cautious in doing that, not reflexively do it just because at the moment this seems politically desirable? And all of that is to say that everything kind of works together for good if people in good faith sort of put that veil of ignorance on and think about how it would feel if someone did this to me. And Justice Kavanaugh's example is a good one. But the end of this story, if we end up having to say Supreme Court's not going to do it, Congress is not going to do it, so we'll do it ourselves and see how California likes it, that's not a good development for freedom. It's not a good development for federalism. It's not a good development for our national experiment, and I hope that we don't go down that path.
Great. Well, we've got a few minutes left for questions from the audience. I think there are a few volunteers walking around with cube-shaped microphones that look kind of funny, but I'm told work. Yeah, maybe let's start down here at the front.
Thank you very much for coming out. I'm about to start my 1L year, so I want to say that listening to all of you is very formative for, I guess, my intellectual journey and just learning more about the law in general. I wanted to touch on a few of your comments, actually. Judge Young, you concluded by saying that federalism is needed so that we don't allow judges to be political activists, and that's something that I do agree with. But then Judges Bolick, Judge Johnstone, you mentioned how the history is that Madison, was once a Federalist and then nationalist and then advocated for states' rights after he lost the political battle per se. So, and you did say, Judge Bolick, that the Democrats have become more Federalist in California. So I'm wondering, if you look at the Supreme Court, they're saying they're getting all these Federalist decisions out, or pro-Federalist per se. If federalism can be politicized in, some examples, at least when I'm looking at other Federalist-cited cases, should I be thinking that that is a legitimate decision? Should I be thinking that that is politicized? And how do you all, in your practice, make sure that this isn't just a political decision, this is more of a judicial interpretation decision strict to the text and the law itself?
Well, I think you have to look at it case by case, right? We've talked about, and I think our justice friends are a little more free to do it than my circuit judge friend, but in terms of that's what the job is in terms of judging. I guess I'd say with respect to it, and I think I certainly can't say it better than Justice Young in terms of the values here. I would look to Professor McConnell has a seminal work on this in 1987 that really walks through his review of the framers' design. There's one more piece, again, not to leave on a down note from James Madison, that after it was all done and it was ratified, I think speaks to a little of this. And he understood that any federal administration is going to have its critics in the state. And this was before the Virginia resolutions. This was after ratification. But the idea was, and I think that, in terms of the politics of this, that he understood that we would keep the Federalist debate alive in our continuing discussions in kind of the best spirit of the Republican form of government. And just because it's such a nice note, at least for me to wrap on, what he said was, you're going to have people who are pro-Federalist and anti-Federalist. You have people who are pro-Federal administration, anti-Federal administration. But what he ended with, let it be the patriotic study of all all of us here certainly, to maintain the various authorities established by our complicated system, none of this is easy, each in its respective constitutional sphere, and to erect over the whole one paramount empire of reason, benevolence, and brotherly affection. And I think that's another way of getting at what Justice Young talked about, is that we ought to be understanding that these discussions here are not merely kind of political debates. They are a feature of the system. That contestation is part of what it means to be in a union together and have these conversations in the hope that they never end in rupture or don't end again in rupture. And I think Madison, for all of his political savvy, also left us with some good feelings, I think, about the system.
That is a great response. I also want to, where are you going to law school?
Right here.
Yay, okay. It will be great to have you. So somebody has to be consistent in applying the neutral values of our Constitution, including federalism. And that somebody is judges. I remember when Judge Gorsuch was up for the U.S. Supreme Court, and he said, if you agree with all of your decisions, you're probably not a very good judge. And so I think for observers and critics of the courts, holding the judges to a level of consistency that we could never hope to hold our politicians to is not only legitimate but absolutely essential. And I not to close with an incendiary remark, but the recent tariff decision I think is a really, really great study on that. 3 justices who were not known to be textualists took what they described as a very textualist position, and I would say to them, the water is great. Thank you. Please stay here. 3 justices who supported the recognition of the major questions doctrine found exceptions to that doctrine, and I think it is legitimate to test those exceptions against the rule when it was created. So that's my response, and I hope that I live up to that. I sure as heck try to, and I know my colleagues, all of my colleagues, both on the court and here on the panel, do their best to do that. But it is our job to be the guardian of neutral constitutional principles.
And all judges say that, right? I will promise to uphold the law as it's written, as not as I wish they were written. I'll set my personal preferences aside. I've heard many, many speeches in Texas for people running for judge. I've never yet heard someone say, elect me for judge, because if you do, I will follow my personal preferences instead of the law, and I will set... Yeah, exactly. Yeah, sometimes they're open maybe in other places, but I've never heard one yet to do it. And the question is, well, are they actually doing it? And I honestly don't think there are that many judges that become judges. There might be a couple who say in their mind, I'm going to just try to subvert everything and rule the people as a judge. The problem is, I think that a lot of judges don't exactly know how to make sure that they're setting their personal preferences aside, which is one of the reasons that we want judges who are experienced and have thought very deeply about this, have the commitment to make the hard decisions. I agree, Justice Bolick has now twice made a variation of the point that if you like all of your rulings, I think Justice Scalia said this before Justice Gorsuch did, then either you're one heck of a lucky person, statistically, like you should be buying lottery tickets, or you're a terrible judge. And that's the most likely one. And one final thing about it, we don't promise, this is distinct from the other branches. When we take our oath, and when I took my oath, my hand was on Sam Houston's Bible. Imagine that as a Texan, putting your hand on Sam Houston's Bible and taking the oath of office. We don't promise to like our rulings. The promise that we make is to make sure that to the best of our lawyerly ability that they are right, that they accurately reflect what the law is. And in order to do that job, to keep that oath that you make to God, you have to have the ability to understand and do the hard work of figuring out what did this text mean to the people who adopted it in 1876. Because whatever it meant to them then is what it still means today, unless they've amended it, because only they have the authority to do that. If it means something else today, that means that somebody else besides the people who adopted it have changed its meaning. Who could that possibly be? And we can all agree to that, but unless you do the hard work, the years of training and thinking and sweating, as Justice Scalia did, he should be an inspiration to everyone because he made all sorts of rulings, the outcomes of which he hated. He was the deciding vote to allow people to burn the American flag. And he would personally have just as soon chopped off their head. But he said that choice was made by the people of the United States who adopted the First Amendment. But in order to do that, he had to understand what it meant, why it meant what it meant in its context, and that is hard work. It's not the matter of what seems right to me. And if someone can't do that, that doesn't mean they can't be a good civic leader. It means they probably shouldn't be a judge.
Great. We have time for another question or two, maybe. Yeah, down here at the front.
Hey there, Tate Kaufman. I'm a third year at Scalia Law School. On the subject of national pork producers, the issues in that case are especially pronounced in the area of cyber law and now artificial intelligence, where states, especially California and now with AI, Texas and Colorado have somewhat become de facto national regulators of those industries. I'm wondering, from the perspective of federal preemption, what is the proper role of the federal government in preempting regulation in industries like that? Is it just to create consistency among the states, or is it also to create a ceiling in regulation, as was proposed with the potential AI moratorium?
Does anyone want to take that one on?
My guess is, I think both, if I understood the question correctly. And I think you're right to kind of be looking to what are the next areas where there's going to be a great temptation for states to try to dictate national policy. Not to harp on California, but I mean, they have some very aggressive environmental laws, electric car mandates. I'm not as familiar with the AI regulations that you're describing from, did you say Texas and another state?
Texas and Colorado, yeah.
Texas and Colorado. But I mean, these are some of climate change and AI are going to they are much bigger issues than how the pigs are raised in Iowa. And I think all I can say is I agree with you that I mean it's those are the areas to, I think, keep your eye on, and the area where Congress, to Justice Young's point, to Em's point, you know, it might be nice if Congress passed a few more laws sometimes when we need number one, when we may need a ceiling on regulation, and number two, where we may need uniformity in a nationwide market. If I can ask the last question, I don't know if we're out of time. Why are the microphones shaped like Kleenex boxes?
Does anyone have an answer to that question? I have no idea.
Somebody holding the mic should be answering.
That wasn't in the script we were given, so I'm not too certain.
Keep waiting for the Jack in the Box to hop out of that thing.
I'll find out for you, though.
Well, I think we've come to the end of our time. So will you all join me in thanking our panelists?